Grab the popcorn again, guys. I got another crazy one. It's just been that kind of week. So one of the things that is particularly annoying to judges are pro se plaintiffs. And there's absolutely nothing wrong with being a pro se plaintiff as long as you play by the rules and you respect the court. You do what you're told and you make an effort to learn the rules so that you don't violate the rules, and also so that you can properly get your matter heard before the court. Because things come into evidence in court in very predictable ways. And if you don't know how to get information in front of a court, then you have difficulty. But the other thing is, there are rules, whether this is state court or federal court, there are always rules about playing fair and getting information from and to the other side. And when you break those rules, there can be consequences beyond just a simple slap of the wrist. Now, today we have a case, I'm not going to mention the name of the client, but we have a case from the 7th Circuit, which is generally Illinois, Indiana, Wisconsin, where a gentleman sued under the Americans with Disabilities Act and the IDEA, Individuals in Education with Disabilities Act. So what he's suing for is certain accommodations, and he filed his lawsuit in state court, which he certainly had every right to do. So state courts have jurisdiction that crosses over with federal jurisdiction in cases like that. But the defendant did what it was authorized to do. It removed it from the state court to federal court. And I have a video on here about what removal jurisdiction is and how it's done and that sort of thing. Feel free to check that out if you'd like. Now, what happened here is the first thing that happens in any of these lawsuits is after you get the case filed, the first thing the defense does is it files a motion to dismiss, and that's what happened. The defense filed a motion to dismiss, and the federal judge in charge of that case reviewed the motion to dismiss and said, no, I think he has credibly alleged violations of the Americans with Disabilities Act. So I'm going to take the unusual step, since he is a pro se plaintiff, of appointing counsel to represent him. And he appointed an excellent law firm to represent him. He appointed the law firm of Jenner and Block, which is a Chicago law firm, a Chicago-based law firm anyway, that has an excellent reputation, and they do excellent pro bono work. They are good lawyers. But that was not what this particular plaintiff wanted. From the opinion, plaintiff rejects appointed counsel. In April 2021, Judge Tharp, sua sponte, that means on his own motion, appointed counsel from Jenner and Block to represent plaintiff. Almost immediately after the appointment, plaintiff told counsel that he was not interested in being represented because you guys don't know what's in my best interest. Counsel explained that his firm had been appointed pro bono and that plaintiff would not have to pay anything for this representation. However, plaintiff refused the representation and ultimately stopped responding to counsel's emails. After counsel notified the court that the plaintiff had refused representation, Judge Tharp set a hearing to discuss the representation order or issue and ordered the plaintiff to appear. However, plaintiff failed to appear at that hearing. Judge Tharp permitted counsel to withdraw and referred the case to the undersigned, who in this case was a magistrate judge, for discovery supervision. Counsel for the defendant in that case filed for a deposition. When the remote deposition began, the plaintiff made a series of statements suggesting that he was recording the deposition on his cell phone. Plaintiff had not served a notice under the federal rules of his intent to do so. So as you might expect, the defense counsel objected that he didn't consent, and he repeatedly sought to confirm whether the plaintiff was in fact recording the deposition. After the plaintiff refused to directly respond to counsel's question, defense counsel canceled the deposition. Several days later, the plaintiff sent an email to defense counsel in the undersigned chambers that contained some rather interesting language. You can't stop me from doing the right thing by law, or you gon' cause yourself to get in legal trouble. For the record, I'm claiming I got proof you was dishonest at the deposition. I am going to benefit from your bad decisions all because you decided not to be careful with your words. It's on record, and don't forget you're under oath as an attorney. Do you realize you violated the law in so many ways? We can settle this right now for $200,000, or I will expose your wrongdoings to the people of the public so that we can judge your mistakes and use it against you. The really funny thing here is he thinks he can settle this case, or basically extort a settlement, for $200,000 based on some vague threat that this man violated the rules of court or the rule of law, when it's pretty obvious that he didn't. So what does the court say about that? From the opinion. The court forbids plaintiff to record his second deposition. Defendant subsequently moved to compel plaintiff to appear for a second deposition, and the court granted the motion. The court also issued a protective order forbidding the plaintiff to record his second deposition by any means whatsoever. In so ruling, the court found that plaintiff's obstructionist behavior during the first deposition and his attempt to use a recording of the deposition posted to YouTube to harass or threaten defense counsel weighed strongly in favor of granting a protective order to ensure such conduct does not recur. Despite being convinced that plaintiff's conduct at his first deposition was purposeful and meant to frustrate defense counsel's questioning, she did not impose costs. That was very gracious because she certainly had the option of imposing costs for that first deposition. So how does the plaintiff in this case respond to that little bit of grace and the slap on the hand? Well, if you had recorded his second deposition on your bingo card, congratulations, you win. Plaintiff violates the protective order and records his second deposition. Plaintiff appeared for his second remote deposition on November 19, 2021. At the outset, plaintiff refused to directly answer defense counsel's question whether the plaintiff understood he was prohibited from recording his deposition. Plaintiff also refused to provide a straight answer when asked whether he was recording the deposition, stating only that he was doing lawful activities. Deciding that any further attempt to establish whether plaintiff was recording the deposition would be futile, defense counsel elected to proceed with the deposition. Yet plaintiff continued to obstruct the deposition by providing evasive or nonsensical answers. For example, when defense counsel asked whether plaintiff was taking any medications that could affect his deposition testimony, personal information, he said, plaintiff responded that he had every right to protect my personal information, my private information, my confidential information from the general public for my safety. Plaintiff then gave that or a substantially similar response to dozens of defense questions. So, star note, pro tip, helpful suggestion if you're ever in this situation, obstructing a deposition is not a good idea. How does the court respond to his doing this? Well, the court was not particularly happy. From the opinion, plaintiff refuses to comply with the court's order directing him to remove the deposition recordings from YouTube. On February 2nd, 2022, the court granted in part defendant's ensuing motion for sanctions. The court found the plaintiff willfully violated the November 5th protective order by openly recording the deposition and posting the recording on YouTube. The court further found that plaintiff's refusal to respond to defense counsel's question at the second deposition, whether he was aware of the November 5 order, only underscored that plaintiff was acting in bad faith. Finally, the court ordered plaintiff to remove the recordings of his depositions from YouTube within 7 days and to file an affidavit confirming that he had done so. So, again, she did not impose costs. a very gracious thing for this magistrate to have done. The next day, plaintiff filed an affidavit, a document that was neither notarized nor accompanied by a declaration made under penalties of perjury that its contents are true and correct under 28 U.S.C. section 1746, stating that he, quote, never posted any recorded deposition on YouTube. Rather, plaintiff only posted a public conversation on YouTube between me and the defendant on the day of the deposition because it's supported and protected by federal law. 2, plaintiff also claimed that it's against the law to force me to take down public records. Plaintiff then reiterated his position that he was entitled to record his depositions and that you gonna cause yourself to get into legal trouble because it's against the law to assume and mislead the court with false information about something that never happened. As of the filing of this report and recommendation, the recordings of both depositions remain on YouTube. So what do you suppose is going to happen to him? So here's how the court begins the next portion of the opinion. Legal standard. Courts have the power to dismiss a lawsuit with prejudice as a sanction when a party violates a discovery rule or disobeys a court order that allows a court to control its docket or manage the flow of litigation. Rule 37 authorizes a range of sanctions, including dismissal of a suit, for a party's failure to comply with court's discovery orders. Sanctions are appropriate when a district court finds that a party failed to comply with the discovery order because of willfulness, bad faith, or fault. Sanctions imposed under Rule 37 must be proportional to the severity of a litigant's misconduct. So what do you think? Do you think that his misconduct has been particularly atrocious? Well, the court did. In sum, plaintiff has willfully violated multiple court orders and the rules of civil procedure, and the record is clear that plaintiff is not litigating this case in good faith. The undersigned therefore respectfully recommends the district judge sanction plaintiff under Rule 37 by dismissing his case with prejudice. Now, I don't have the subsequent opinion where the district court did that, probably because there was no need to issue an opinion. The judge probably simply issued an order in that matter. After continually violating orders issued by the court, thinking he was smarter than the court, he wound up figuring out that he wasn't nearly as smart as he thought. So hopefully that teaches some interesting lessons here. I realize it's kind of a text-heavy case today, and there's a lot of reading here going on. But I hope you found this interesting and helpful and something that is a little bit funny maybe, because there's absolutely no reason to go into court and act like you know everything when you know literally nothing about the procedures. If you have any questions on this case, leave them in the comments down below. I'll do my best to answer them. If you haven't already, please go over here and subscribe to our channel and tap the notification bell so you can be notified whenever we release a video on this channel. And then finally, if you haven't already, I'd appreciate it if you'd give me a thumbs up, like, share, subscribe, all that stuff. We greatly appreciate it. Thank you so much for watching. Have a terrific day.